5 seconds to go. Start. Every accused shall be supplied with statements of witness recorded under sections 161 and 164 CRPC and a list of documents, material objects and exhibits seized during investigation and relied upon by the investigating officer IO in accordance with sections 207 and 208 CRPC. The list of statements, documents, material objects and exhibits shall specify statements, documents, material objects and exhibits that are not relied upon by the investigating officer. In view of the above discussion, this court holds that the prosecution in the interests of fairness should, as a matter of rule, in all criminal trials comply with the above rule and furnish the list of statements, documents, material objects and exhibits which are not relied upon by the investigating officer. The presiding officers of courts in criminal trials shall ensure compliance with such rules. It may be noted that the draft guidelines were given by this court to all the high courts and the state governments and Union of India in the suo motu proceedings initiated by this court under Article 32 during the course of hearing of a criminal appeal, whereby the court had noticed certain common deficiencies occurring during the course of criminal trials and certain practices adopted by the trial courts in the criminal proceedings. The said suo motu proceedings were registered as Criminal Trials Guidelines regarding inadequacies and deficiencies in Re versus State of Andhra Pradesh and others. The said case related, amongst others, to deficiencies lapses with regard to the manner in which the documents, list of witnesses, list of exhibits, list of material objects referred to and presented and exhibited in the judgments, and lack of uniform practices in regard to preparation of injury reports, deposition of witnesses, translation of statements, numbering and nomenclature of witnesses, labeling of material objects, etc., which often led to asymmetries and hamper appreciation of evidence, which in turn had a tendency prolonging the proceedings, especially at the appellate stage. The court in the said case had noticed that on these aspects some high courts had framed the rules, however some had not, which had led to a lack of clarity and uniformity in regard to the presentation of trial court proceedings and records for the purpose of appreciation at the High Court and Supreme Court level. The court in the said case, after considering the suggestions, submissions of the amici curiae and of the councils appearing for the High Courts, States and the Union Territories on the draft rules of criminal practice 2020 prepared by the amici curiae, had given the following directions via the order dated 20th April 2021. The court is of the opinion that the draft rules of criminal practice 2021, which are annexed to the present order and shall be read as part of it, should be hereby finalized in terms of the above discussion. The following directions are hereby issued. All high courts shall take expeditious steps to incorporate the said draft rules 2021 as part of the rules governing criminal trials and ensure that the existing rules, notifications, orders and practice directions are suitably modified and promulgated wherever necessary through the official gazette within 6 months from today. If the state government's cooperation is necessary in this regard, the approval of the department or departments concerned and the formal notification of the said draft rules shall be made within the said period of 6 months. The state governments as well as the Union of India, in relation to investigating agencies in its control, shall carry out consequential amendments to their police and other manuals within 6 months from today. This direction applies specifically in respect of draft rules 1 to 3. The appropriate forms and guidelines shall be brought into force and all agencies instructed accordingly within 6 months from today. From the above, it clearly emerges that this court in the aforestated suo motu proceedings had directed all the high courts to take expeditious steps to incorporate the said draft rules as part of the rules governing criminal trials and to ensure that the existing rules, notifications, orders and practice are suitably modified and promulgated wherever necessary through the official gazette within 6 months from the date of the said order. The court had also directed the state governments as well as the Union of India to carry out consequential amendments to the police and other manuals. However, neither the High Courts nor the state governments appear to have taken any steps pursuant to the said directions. As a result thereof, the said draft rules have neither been adopted by the respective High Courts, state governments, nor have come into force, unless and until the draft rules as suggested by the court in the suo motu proceedings are incorporated by the High Court in the rules governing criminal trials, and unless the consequential amendments are made by the state governments and the Union of India in the police and other manuals, the same could not have been pressed into service by any party to a criminal proceeding. Stop.